Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello, welcome to podcast 160. We've got three cases, of course, one of which deals with a decision which is hot off the press today on workers and the transfer of undertakings regulations. The second case relates to an email that was leaked to a claimant and in which we wish to rely on that as part of his claim. Could he do so? And the third is to do with a costs appeal and some comments the judge made about payment of legal fees. I hope you've had a chance to listen to podcast number 159. It was a shining example of its kind, I hope you'll agree. Anyway, having decided to devote an entire episode to IR35, I think you understand my concern to learn today that the Labour Party has said that it intends to scrap the introduction of IR35 to the private sector with effect from April 2020. The Labour Party is calling for a fundamental review of the legislation before there's any extension. Obviously, it'd be deeply frustrating if the Labour Party were to do this after I've taken the time and trouble to do a podcast. So it's probably all for the best that we're going to end up with a considerable majority Conservative government under Boris Johnson. And clearly, if I had an irony alert klaxon, it'd be going off full volume by now, just to avoid any misunderstandings. Anyway, obviously to the extent there are any changes to the IR35 rollout, we'll keep you updated on the podcast. Please don't forget, usual wording, podcasts available via iTunes, Mayer Brown website, YouTube, Twitter, Spotify, Google Play and Yahoo. So let's deal with that for the first case, Dewhurst Merchant and McQuaid and Revise Catch Limited and City Sprint UK Limited. This is the case that was decided yesterday, so most definitely hot off the press and became public this morning. Why the great rush, I hear you say? Well, I think it's a really interesting case dealing with a point which I have to say has troubled me for some time. It's an employment tribunal case, and as such, it doesn't actually set any binding precedent. But I think the case is going to get a load of publicity, and employers do need to know about it urgently. Background is the claimants worked for a courier company. Each of them was engaged to provide services to a courier company. City Sprint had engaged them and then lost the right to provide a courier contract to a particular end user. Revise Catch took over that contract, and so the first respondent in this case is the new employer, or transferee for TUPE purposes, and the second respondent is the transferor for TUPE purposes. It was the transferee and the employee slash claimants who were fighting over this particular preliminary point. I should emphasise, it was all done on the basis of assumed facts, so the underlying factual position is yet to be clarified. But in essence, the claimant's case was that they were workers, and I'll come back to that point in a second. As such, the TUPE regulations, they said, extended to give protection to workers in relation to collective consultation claims and in relation to the automatic transfer of contractual rights from the transferor to the transferee. In this case, they wanted to make claims on holiday pay, and they said that the outstanding holiday pay claims or rights transferred across from the transferor to the transferee. And this was clearly right if they were covered by TUPE based on the assumed facts. So, who does TUPE apply to? Well, that's a surprisingly difficult question to answer. It applies to someone who is an employee, but there's a special definition in Regulation 2.1 of TUPE 2006, which provides that an employee, for the purpose of the regulations, is, quote, any individual who works for another person, whether under a contract of service or apprenticeship or otherwise, but does not include anyone who provides services under a contract for services, and references to a person's employer shall be construed accordingly. So let's start with the bits of that are clear, shall we? If you work under a contract of employment, then you're an employee. Okay. If someone is genuinely self-employed, i.e. working under a contract for services, they are not a TUPE employee. So far, so good. But the definition, in effect, says that you're an employee for TUPE purposes if you work under a contract of employment or apprenticeship or otherwise. What do the words, quote unquote, or otherwise mean? And I have to say that this is a point, as I say, that's troubled me for some time. It's troubled us for some time. And we had one case where we were seeking to argue that an equity partner in a law firm was covered by a TUPE transfer because their relationship was covered by the words, quote, or otherwise. Sadly, it settled before we came to a landing on that. But I think the natural reading of the definition of employee is that you're deemed to be an employee for TUPE purposes unless you're genuinely self-employed. In other words, the rule is you're an employee and the exception is that you're not an employee. The wording, or quote, or otherwise, unquote, is pretty broad brush, let's face it. But what did the tribunal decide here? Well, after a careful review of both the European legislation and the domestic legislation, the tribunal worked out it had to decide whether someone who could properly be described in a different context as a Lim B worker was an employee for the purpose of TUPE. Now, Lim B worker is one of those bits of jargon where everyone knows what it means without necessarily feeling the need to spell it out entirely. So, the definition of a worker is, of course, intended to be someone who's an intermediate category of individual, somewhere between a full employee and someone who is fully self-employed. And as we all know, most statutory rights apply to employees, then some statutory rights apply to workers, and relatively few statutory rights apply to the genuinely self-employed. A Lim B worker is someone who's not an employee, as such, under a contract of employment, but who is working under a contract, quote, whereby the individual undertakes to perform personally any work or services for another party to the contract, whose status is not, by virtue of the contract, that of a client or customer of any profession or business undertaking carried on by the individual. Let's just unpack that bit by bit. So Lim B applies to someone who's not an employee, but who is providing personal service under a contract, point one, but they're not carrying on a business or profession on their own account. If the individual is carrying on their own profession or business, they are not a Lim B worker. So the short question for the tribunal was whether this intermediate category of worker, which can clearly cover people who are not employees in the ordinary sense, was to be understood as being covered by the extended definition of employee in TUPE. The crux of this case, and I emphasise again the facts are only assumed at the moment, was that it was assumed that if the motorcycle couriers that were not carrying on business on their own account, but were contracted personally to provide services to City Sprint, they would then be Lim B workers. Was that enough to ensure that they were covered by TUPE when City Sprint lost the business in which they worked? Claimant's assertion was that the definition in TUPE was intended to apply to any employee relationship which went beyond those governed purely by a contract of employment. So it was necessary to look at how employment had been defined in relevant UK legislation generally, and to take the wider tests and apply that to TUPE. Since Lim B workers are defined as employees for discrimination purposes, that's the way workers are given some of those statutory rights that I mentioned earlier, that meant that workers here would be caught by the definition of employee too, it was argued. The respondents' counter-argument was that there was a clear distinction between contract of service on the one hand and a contract for services, and that this fundamental distinction was preserved by TUPE, which referred to contracts of service on the one hand versus contracts of services on the other, i.e. self-employed. In essence, the Employment Tribunal judge, after a very careful and clear review of the authorities, came down in favour of the claimants. The Equality Act 2010 has an extended definition of employees, and that includes so-called Lim B workers. The tribunal judge decided that the Acquired Rights Directive, and therefore TUPE, looked to protect the employment relationship, including the extended definitions of employment found in UK employment legislation. Judge also pointed out that the recital in the Acquired Rights Directive, which is an aid to the interpretation of the directive and therefore the legislation, the UK legislation, expressly looks to ensure that employment rights are transferred and preserved, and this, the judge felt, was consistent with the judge's interpretation of the 2006 UK legislation. The judge finished by saying that if this view was wrong, then it would be necessary to read into the UK transfer regulations wording to protect the worker's relationship, rather than the narrow definition of employee, to give appropriate effect to the Acquired Rights Directive. This went, the judge said, with the grain of TUPE, i.e. preserving employment and the rights of those who work within an undertaking when that undertaking changes hands. It's quite difficult to argue with that. Now, clearly, this is an important case, extremely important case, if it heralds the start of a new front in the consideration of an individual's statutory rights. Now, there was an earlier stray tribunal case, which I have seen reference to, where apparently the tribunal came to the same sort of landing. But that was a number of years ago, and not a lot of attention seems to have been paid to it for whatever reason. But it must be likely that in this environment, with this decision getting this publicity already, that the decision will be appealed. And certainly if this decision isn't appealed, the cases that follow in its wake, one or other of them will end up in the Employment Appeal Tribunal and beyond. I mean, that must be a certainty. So this is going to be widely known. But more importantly, perhaps, how should employers dealing with TUPE transfers address these concerns now? Well, first of all, it's necessary to establish whether you have any Lim B workers within the organisation. Many contractors are provided via intermediate service companies, so there's no direct personal contract between the individual and the end user. In general, this tribunal case has no application for such individuals. Of course, it's always possible for those individuals who are being provided via an intermediate service company to transfer under a TUPE transfer from the intermediate service company directly to the end user. But in many cases, the arrangements continue unchanged. It is simply the customer that changes, the new entity continues to provide the services of the contractor to the new customer. So there's no TUPE transfer at all for an individual who is being provided via an intermediate service company. So what we're looking at really are predominantly people who are providing services personally and directly to a customer/employer. Here, the claims are related to accrued but untaken holiday pay and collective consultation. I think it's relatively straightforward to ensure that contractors who might be viewed as Lim B workers are given the right to vote in and stand for election as employee representatives and are then covered by the consultation. It may be necessary, I think, to look at existing standing arrangements to see if those arrangements can be adapted to cover workers who are not working under a contract of employment. Secondly, the courier's claims also related to accrued but untaken holiday pay, which they said had transferred over by virtue of TUPE. Well, that's a case of adapting warranties and indemnities where these are being provided so that they cover claims by workers as well as by employees, and frankly that may be less of a change depending on how those warranties and so on have previously been drafted. For my purposes, I think the bigger question is whether this could lead to a claim that workers have, in effect, unfair dismissal rights. It seems to be an entirely logical step to argue that if individuals are covered by the Acquired Rights Directive, and by virtue of that directive they have the right not to be dismissed by virtue of the transfer, then that is a right envisaged by the directive. At the moment, I think it's clear that the test for unfair dismissal refers to employees as ordinarily understood, excluding Lim B workers. That much is pretty clear. But it seems to me a short and pretty logical step to argue that the UK's implementation of the transfer regulations would be defective if it fails to give adequate rights to enforce entitlements given by the Acquired Rights Directive. That's clearly some way down the line. It's a fight for another day. Equally, I could see that argument being used against the tribunal decision in this case, i.e. it cannot be right to give workers right to claim unfair dismissal, and therefore this decision, which gives workers the right to collective consultation, is also wrong. We live in interesting times. This one, I think, will run and run. So that's Dewhurst, Merchant and McQuaid, and Revised Catch Limited and City Sprint UK Limited. Secondly, Curless and Shell International Limited. So the background to this is that Mr. Curless was a senior legal counsel at Shell. He had health issues, and it seems there were also concerns about his ongoing work. Matters deteriorated, and in 2015 he put in a claim asserting disability discrimination. Following a corporate acquisition, Shell was making a number of redundancies. Mr. Curless was unsuccessful in applying for ongoing roles and was put at risk of redundancy, and then in November 2016 was given notice of redundancy. He then started a second claim alleging disability discrimination, victimisation and unfair dismissal. His argument was that the redundancy exercise was a sham, and he said he was dismissed because of his disability or because he had done a number of protected acts. Well, the factual basis for his second claim was two separate incidents. In May 2016, he said he'd overheard a conversation at a bar on Chancery Lane between two lawyers who he believed to be from Shell's external employment law firm. They did not refer to him by name, but the conversation led him to believe that they were talking about him. Then, in October 2016, he was anonymously sent an email, which was between an in-house lawyer and an external lawyer seconded to Shell. I'm going to read out the email in a moment, but the gist of the claimant's argument was that he was entitled to use both the conversation he overheard and the email he was sent, although they might otherwise have attracted legal professional privilege, because legal privilege cannot be used as a cloak for iniquity, and so the privilege label was no longer applicable. The email in question recorded a conversation with another internal lawyer. So lawyer A writes to lawyer B, telling lawyer B about a conversation A has had with lawyer C. The email sets out there are to be a number of reductions at overall senior lawyer level within Shell UK, and then quote, I told them this is their best opportunity to consider carefully how such process could be applied across the board to the UK legal population, including the individual. If done with appropriate safeguards and in the right circumstances, whilst there is always the risk, you would argue, unfairness/discrimination, there is at least a wider reorganisation and process at play that we could put this into the context of. I felt in the circumstances this is definitely worth considering, even if there is the inevitable degree of legal risk which we would try to mitigate. Obviously, we risk impasse and proceedings with ongoing employment with no obvious resolution. It was accepted the reference to the individual was a reference to Mr. Curlis. The Employment Tribunal accepted the email and the conversation were both privileged. They said the conversation related to the provision of legal advice, and so the email recording it was also privileged. There was nothing iniquitous in what was said in it. It is what lawyers do, quote, they said, day in, day out, unquote. The Employment Tribunal accepted Mr. Curlis had overheard the conversation on the 19th of May in the terms that he said, but again said it's covered by privilege. The EAT disagreed. The EAT's interpretation was that the email was recording legal advice that the genuine redundancy exercise could be used as a cloak to dismiss the claimant. The EAT judge continued that it was an attempt at a deception of the claimant, and if persisted in, would have been a deception of the Employment Tribunal in relation to likely and anticipated legal proceedings. The email concentrated, the judge said, exclusively on how the redundancy could be used to rid the respondent of ongoing allegations of discrimination by the claimant. She also said that it was not appropriate to rely on legal advice privilege in relation to the conversation that had been overheard a couple of weeks later. So what do you think the Court of Appeal did? Well, the first thing they had to do was to decide whether or not the case was going to be decided without naming the parties. Shell made an application for an anonymity order on the grounds that if the appeal was successful, it would be inappropriate for a future tribunal hearing the liability case to be aware of this decision, and therefore the material which, hypothetically speaking, was going to be excluded if the appeal was successful. The Court of Appeal having none of it. It was a plainly inadequate ground for qualifying the operation of the principle of open justice, they said. Judges were well used to disregarding evidence which was to be excluded. Secondly, the Court of Appeal agreed with the Employment Tribunal's view of the email and disagreed with the EAT's interpretation. There was no dispute that there were to be redundancies. Shell was seeking legal advice on how the individual could either be offered voluntary redundancy or dismissed on the grounds of redundancy. Legal advice had been given on how processes could be applied to him, quote, with appropriate safeguards and in the right circumstances, unquote. The writer, according to the Court of Appeal, was looking at two alternative risks. There was a risk that if the claimant was selected for redundancy, he would argue the dismissal was unfair and discriminatory. On the other hand, if he was not considered for redundancy and remained in employment, the first claim would continue anyway, and there was a risk of an impasse. The Court of Appeal agreed that this was the sort of advice which employment lawyers give day in, day out, not advice to act in an underhand or iniquitous manner. Similarly, the subsequent conversation could not be relied on to interpret the email, and there's no evidence the person speaking had seen the email, so advice in an email could not be tainted by a conversation involving gossip with someone else after the event. On that basis, the issue of iniquity didn't arise. So obviously an unfortunate set of events, but not exactly an unknown one, where casual gossip or a leaked email could have caused problems to the employer. I think on balance I'm with the Employment Tribunal and the Court of Appeal and against the EAT. I don't think the email does amount to an attempt to deceive the claimant or the tribunal. But I think it does show that the iniquity exception, although not engaged here, is a high threshold. And of course it's a reminder to all who advise employers that walls have ears, and that is a fact. Finally, and I cannot claim credit for this unfortunately, I've seen an article on this case under the truly marvellous title of Curlis Whisper. I doff my cap. So that's the case of Curlis and Shell International Limited. Final case, Solomon and University of Hertfordshire. And I think this case may get cited by claimant lawyers quite a lot, so I wanted to deal with it relatively briefly. It's an EAT case to do with the costs appeal. The claimant had been ordered by the tribunal to pay £20,000 towards the respondent's costs, following the rejection of the claimant's allegations of unlawful discrimination, victimisation and harassment. The tribunal's findings were based on the fact that the claimant withdrew from a judicial mediation, had failed to take advice on an offer of settlement made by the respondent, which included an additional £500 for her to take independent advice, and then there was a further offer of settlement after the merits judgment had been put forward. The EAT allowed the claimant's appeal against the costs order. They pointed out that there may be more than one reasonable course to take in any given situation, so the fact that it would have been reasonable to accept an offer, a settlement offer, does not make it unreasonable to reject the settlement offer. The tribunal should be reviewing the decision taken by the litigant rather than substituting its own view. And the EAT decided the tribunal had substituted its own discretion for that of the discretion of the litigant in person. The question it should have been deciding was whether the decision taken by the litigant was, quote, within the parameters of reasonableness, unquote. In that context, the EAT said that if the offer of £500 for legal fees was to cover advice on the merits of the settlement, then the offer of £500 was manifestly unreasonable. It would have been reasonable if it related to the terms and effect of the proposed settlement agreement only, and its effect on her ability to pursue her rights thereafter. That was relevant because if the individual was being provided with the costs of legal fees to advise her on whether or not to take the settlement, that might be an indication that the settlement offer was more likely to be one which it was unreasonable for the claimant to refuse. A claimant could be expected to take legal advice in those circumstances, I suppose, if complete cover for fees was being provided. Anyway, here, because the tribunal had viewed the decision as a question of what it thought was reasonable, rather than whether the claimant's decision was outside the bands of reasonableness, the appeal was allowed, and the application for costs and a cost application was remitted for a rehearing. Before I go on to what I think is going to be the main point of this, I did want to say a few thoughts about offering a litigant in person access to legal advice. Clearly, in principle, this sounds like a good idea, and it may genuinely be done with the best of motives. If you do wish to encourage a non-represented litigant in person to take legal advice, then this case is an indication that you should be offering to cover the costs or the necessary costs of a legal advice if you want to rely on their unreasonable refusal to seek advice about an offer you're making. In other words, I'm not saying that every time you make an offer you need to be offering to pay legal fees separately, but if you want to say, and we also offered legal fees, then you need to make sure the legal fees sum is a reasonable sum. However, I think there's a slight catch here. Most settlement offers I have seen say that the payment of legal fees is conditional on entering into the settlement agreement, and that has a catch to it, because I think a litigant in person will say, well, if I turn down the settlement offer, but I've taken the legal advice, and then you don't cover my fees, I've got a debt. So I don't need to go off and take advice, even though you're offering to cover the legal fees, because that's tying me into taking the money. So is an employer really going to be happy paying, say, £3,000 or £4,000 for a litigant in person to get advice unconditionally, i.e. whether or not the individual then accepts the settlement offer? So in the circumstances, I think that any suggestion that a tribunal should take into account whether or not someone should have taken legal advice on what would have been found to be a reasonable settlement agreement is quite a difficult argument to make. I'm not saying don't try it, but I do think I question whether in reality offering to pay legal fees is going to be the difference between winning a substantive costs award application or not. I think it's going to be too easy for a claimant to find a reason for rejecting it. But my primary reason for mentioning this case is the reference to £500 being wholly unrealistic, and I think that might well be relied on, perhaps mischievously, to try and increase the amount of contribution to legal fees for claimant lawyers being asked to advise on settlement agreements. This case is very clear. The whole discussion is in the context of whether or not the employer could say, not only was my offer of settlement reasonable, but I enabled you to go off and take legal advice, and your failure to do so is in itself unreasonable conduct. In those cases, the employer would probably think it had a stronger case for an application for costs against the litigant in person by doing that. But here, all the EAT was saying was that the costs argument, and we also offer to fund your lawyer's fees, would not work if you're only offering £500. In the context of simply paying £500 to enter into a settlement agreement, as opposed to take advice on a settlement offer in litigation. As we know, the individual merely has to be advised on the terms and effect of the proposed settlement agreement, and its effect on the claimant's ability to pursue their rights thereafter. The EAT implicitly acknowledges that £500 would have covered the necessary minimum level of advice for entering into a statutory settlement agreement. So I do not think, contrary to what employers may be told, this case provides any support whatsoever for increasing the £500 contribution to a settlement agreement. Obviously, we're aware, many cases, many employers pay more towards legal fees. But we still see a number of settlement agreements with those sort of numbers in it as a first draft. A settlement agreement with a contribution of £500 towards legal fees, which is then entered into by the individual, will not be invalidated simply because the individual was only offered a contribution of £500 towards legal fees. There's no obligation on an employer to offer any contribution to legal fees in the legislation, although this is, of course, the almost invariable practice in our experience. So that's the case of Solomon and the University of Hertfordshire. So thank you very much for listening, and please join us again in a couple of weeks' time. I'm hoping to do a Christmas podcast episode looking at the key cases of 2019, and it may indeed be that after the general election some future changes to employment law will become clearer. Who knows? But in the meantime, stay safe. Thank you for listening, and as always, no politicians were harmed or mistreated in the making of this podcast. Thank you.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.